morning, everybody. Hopefully we have everybody there. Just want to check to make sure it is coming through live, to make sure it's fine on your end. So I'll firstly like to say thank you for the great interest we've had in this seminar. We've had some 140 register, so hopefully everyone can connect, and if there's any issues, just shoot through some emails and we can hopefully sort those things out. But it seems that everything else is running smoothly. So firstly, again, we'd like to welcome Michael Murray from Murray's Legal and co-author of Keys Insolvency, as well as Jason Harris, Professor of Corporate Law at the University of Sydney and also co-author of Keys. We've just had a couple of people say that there's no video yet. I'll just double check to make sure it's not our end.
Yeah, if you look, the start video is crossed out.
So I'll keep going, and hopefully if more questions come through, if there are issues about connectivity, just let us know as we go. We've already got questions coming through. So what I propose to do, I just set out just quickly what the schedule is today, and then give the introduction to Michael and Jason. And then I propose, I don't think I'm going to need to say much for Michael and Jason to talk on these topics that are amongst everyone at the moment and are the subject of much discussion. So firstly, I'll just recap on some of Michael's experience. So Michael has over 30 years experience in Australia as an insolvency and reconstruction lawyer, writer and commentator. I think for all of us in the profession, we have read at one point or another their Keys versions. I might actually just segue into a quick question to both of them is when's the next book coming out?
How are your chapters going, Jason?
They're getting there. Yeah, we're going to work on it later this year.
Later this year,
So I'll keep moving on, and we'll shoot across to Michael and Jason in a moment. We sent around, and you'll see some further background on Michael, so I won't repeat all that here, given the time. Jason teaches and researches in the areas of corporate law and insolvency law, commercial law, and contract at Sydney Law School. The rest speaks for itself. Again, a co-author of Keys Insolvency and one of our great resources. Today we're going to broadly discuss 4 topics, although I suspect there'll be a bit of a segue into different topics as we go, potentially. The 3 of us have been talking this morning already about different things that are happening, which is that there's some things in the UK with recent reforms about pre-packs. We can talk for hours. So the general discussion topics this morning will be corporate, small business restructuring and simplified liquidations, COVID safe harbours, tackling phoenixing, credit defeating dispositions and legislation, and sole trader and business failures and the personal insolvency reform. So one thing that no doubt Michael and Jason are talking about is who these reforms are intended to target, but who they actually do target. So what I might do without any further delay is to hand over to Michael and Jason. What we're going to do is have a split screen. They have prepared hopefully some seminar notes and slides. And what I propose to do at the end is to everyone who has registered is circulate the slides, the recording of this seminar and a CPD certificate. So you should receive after this those 3 things. So again, thank you very much on behalf of ERA. We're looking forward to this discussion, and we'll hand over to Michael and Jason.
Do I start now? All right. Thank you very much, Blake. We're live, is that right?
We are.
Good, thank you very much. And thanks, Blake, and to ERA Legal for this invitation. I remember when Blake rang me to asked me about giving this presentation. It was back, I think, December last year, and I remember thinking at the time, well, you know, if we give a presentation sometime in February or March, early in the new year, you know, we'll be seeing the results of this new legislation, and the various government grants will have ended, and the insolvency restrictions will have ended, and we'll be in the midst of you know, assessing the new laws that we have and how effective they are to deal with what was said to be, or a tsunami of insolvencies. Now, I'm no economist, and I'm not saying that that won't happen, but certainly at the moment, things probably aren't as we expected, or aren't as I expected when as I said, I spoke to Blake last December. So today we're in a bit of an unusual position in terms of the market, where Australia has been through in 2020 a significant, along with the rest of the world, social and economic upheaval, which in Australia was countered by, as we all know, a relaxation of our insolvency laws, the limitations on demands and bankruptcy notices and bankruptcy and liquidation proceedings, and also quite extensive government assistance to business and flowing through to consumers. And apart from other parts of the world, which I'd have to say don't look as successful as what we've achieved here, we seem to be coming through it quite readily. Although, as I say, I'm no economist, and that things may yet change. But talking about at the moment, we've just come through a year where the number of insolvencies necessarily dropped very dramatically, but they are still dropping in 2021 according to the latest figures, and that's despite the the end of most of the restrictions on insolvency at the end of December, and I think the final restrictions end sometime in March, at the end of this month, or in a couple of months thereafter. But when the title of this this talk is what is actually going on post COVID-19, I'd just like to rephrase that a bit, because what I'd like to look at is what is going on post COVID-19, and that's what our talk is going to be about. But I'd also like to look at what was going on before, back in 2019, when the idea of COVID-19 was just didn't come into our thinking at all. Because the figures in insolvency back in 2019 were falling at that stage, certainly in bankruptcy, or they were at least plateauing. And why that was happening was a matter of some economic comment at the time. And one thing that I feel may have been a useful outcome from last year, from our perspective, is that it's given us a sort of a resetting, given debtors a resetting and given creditors a resetting, something like a circuit breaker of the ways that things were done up to 2019. As I said, creditors sort of went cold turkey, so to speak, on their usual processes of demands and recovery mechanisms. Debtors were given some quite leniency, or that's the way they might have seen it, in terms of insolvent trading relief and safe harbour provisions. And coming into 2021, I'm just wondering if that has been a useful process last year, and whether creditors have sharpened up their processes in terms of having to deal with the lack of their usual remedies last year, and whether the debtors who have survived and come through 2020 are in fact the survival of the fittest. Have they adapted well to what is a new environment? And are we looking at a range of businesses and where insolvency will continue to remain as more a secondary mechanism, or certainly figures won't restore to what they were before 2020. I've got some doubts about that, which I'll mention in a minute, but I just put this in a broader context, and Jason will be aware of this in terms of education has had to rethink itself in light of last year, and there's a lot more online learning. Retail is now going a lot more online. We're living in a different environment. And so what I'm asking is insolvency impacted by that, or how much? And what might insolvency have to do to reset itself in order to deal with the future? Now, Jason, as I said right at the beginning, when Blake rang me and said, would we give this talk, Jason and I were at the time, we're always, discussing insolvency issues, and we were in the process of rethinking what insolvency is about. And this, as I say, hiatus or lull in 2020 is probably given that a bit of an impetus. But I'll just mention 3 items that we've been looking at. The system is administered by insolvency practitioners who pursue private creditor interests, and we know what we mean by that. But they also take on a lot of public accountability and investigation of misconduct interests. Jason and I would query that. The second point I wanted to make is that both of those interests are largely funded by the remaining assets of the insolvents, that is by creditors. Now, insolvency practitioners, of course, deal with a lot of unfunded matters, but they must recoup their fees from somewhere, and we would say that they recoup them from those estates where there are assets and therefore where there are creditors. Whether that's a satisfactory system is another matter again. And then the maiden creditor interests, and I'll give a quote from Jason in a second, that are really benefited by the insolvency system are government creditors, that is the ATO and FEG, the Fair Entitlements Guarantee. Jason, in fact, wrote back in 2018, if I could quote you, Jason, corporate insolvency by the numbers. Australia has a system that is barely supported by the assets of companies that enter external administration, and certainly not designed to produce meaningful recoveries for unsecured creditors. And he's got some figures which he'll present in a moment that show what limited returns creditors get, except for the government. And then we question, should the government fund it? Putting all that academic thinking to one side, but not forgetting it, maybe I could ask Jason to sort of substantiate what I've just been saying in terms of is there the scene out there in terms of assets of creditors and what assets of debtors and what creditors can expect, and do we pay too much attention to creditors?
Yeah, I guess I'd like to comment firstly on something that you just said there in terms of, the businesses that we're seeing still operating now. Is that really the result of the competition of, the fittest?
Yep.
Have the poor businesses fallen by the wayside? And we might say that in ordinary times, that would be the assumption. Whether that's correct is another matter. But I really don't think we can say that now, because it just feels like, a third or a quarter of the working population have been on the government payroll for the last year.
Mm.
And so the businesses that are still operating now aren't necessarily viable businesses. They're businesses that have been propped up weekend at Bernie style by government support programs. And totally understand during the midst of, an unprecedented global pandemic, it's extraordinary circumstances, but I'm not sure that we're going to see insolvency numbers necessarily rise to their former levels or increase, although last year I thought we would, because I just suspect, and it's easy for me sitting in the ivory tower at Sydney University, but I just suspect that there's an awful lot of businesses that have been hollowed out in the last 12 months. And I'm not sure that they even have the assets once government support programs are removed to even fund an insolvency practitioner. I suspect they're just going to be abandoned. And so we're going to see a lot of businesses that are just, detritus by the side of the road, rather than going off and getting insolvency practitioners to administer their winding up. And that poses all sorts of other important questions about what is insolvency law really for? Is it really about returns to creditors? Is that the measure of success? If we've got a system that more often than not, and in a minute I'll turn to a slide with some statistics, it's not even more often than not, it's in more than 9.5 out of 10 cases, produces no return to creditors. Creditors get nothing. Insolvency law is not about creditors if we judge it in terms of actual outcomes. Now, maybe we might say, well, the problem there is that we're judging it on economic returns to creditors. Maybe that's the wrong measure. Maybe creditors have some value in the reports that insolvency practitioners prepare, or participating in creditor meetings, or receiving circulars and the like, seeing that the law is being enforced through recovery proceedings. But even on that measure, I think we would have to say, as a whole, the insolvency system is largely unsuccessful, because what we know is that many creditors are rationally apathetic, which I mentioned there on the slide. Insolvency practitioners struggle to even get a quorum. The quorum for a creditors meeting is 2 creditors. So if you can't even get 2 creditors to participate, that's a problem with the process. Now, that's not a criticism of creditors, because they're rationally apathetic. If in 9.5 cases out of every 10, they're getting nothing, not 5 cents in the dollar, 0 cents in the dollar, their experience tells them, why would they want to put any effort into participating in an insolvency process that patently is not for them because they get nothing out of it. So I just think that's a signal that there's something very wrong in the system, that our perception of what insolvency law is for and what it achieves just does not marry up with the reality of insolvency. And that's why I've said on that slide, transparency and accountability, but at what cost? It's my view, Michael, I think you might share this view, at least to a certain extent, that what we're trying to achieve in Australia and what we think we're achieving is almost like a Rolls-Royce system of insolvency. It's this idea that we can have an incredibly experienced, highly regulated, independent fiduciary who's managing the assets with full transparency, full accountability, detailed investigations and reporting, processing of offences and breaches of the law by the relevant regulators and returns to creditors. I'm just not sure that we're satisfying many of those aims at all.
But Jason, that can't be right, can it? Because the government's introduced a streamlined restructuring process in Part 5.3b.
Yeah, which, as I'm about to say, I think will be a massive white elephant that will simply not be used very often.
I thought you'd say that.
Yeah. So, I think at some point we need to sit down and have a long, hard think about what it is insolvency law is for. And that shouldn't simply be what it's traditionally been seen to be for. And that's, to a large extent, the problem that I see with the insolvency law reform process. The government keeps trumpeting all these major reforms, and what we're ending up with is the picture that you see on the first slide there, which is a lot of roads going not very far, going nowhere, basically. We're having multiple inquiries. Whilst we might quibble about the terms of those inquiries or some of the recommendations, there's multiple inquiries, both within Parliament and outside of Parliament, that are saying a lot of people in the community are unhappy with insolvency. And I'm not even sure there's a lot of insolvency practitioners that are terribly happy with the way insolvency law works. And that's why I've said on the first content slide that what we've ended up with is a focus on re-regulating the insolvency profession, because the perception of the profession and what occurs in insolvency is skewed by this completely unrealistic and untrue expectation that insolvency is about creditors and returns to creditors. It might be in some very large matters where they're starting with a lot of assets, but in the vast bulk of insolvencies, it clearly is not about creditors, because in almost every case, they get nothing. So I think that's a problem. So yeah, if we just go to the next slide. So over the next two slides, I've got some statistics here that I've pulled out of the ABS and also out of some ASIC reports. I'm not going to take you through each of the points here. There's just a couple that I really want to highlight. I guess, if we think about some of the insolvency law reforms and the interest that they seem to be protecting in terms of employee entitlements, for example, making sure that they're paid up in full before we initiate these new procedures. Look, the vast majority of businesses employ no one. And there certainly are lots of businesses that employ people, but of those businesses that do, the vast majority of them, 69% of businesses that employ anyone, employ between 1 and 4 people. The large proportion of small businesses out there have very little levels of secured debt, at least at the point of insolvency. And what we know, based on these statistics that the ABS put together, is that where you've got businesses with very low turnover and no employees, they're far more likely to fail than businesses that have higher turnover. Higher meaning only above 200,000 a year. Now that's turnover. What sort of asset base do you think a business that only turns over 200 grand a year is going to have? They're not going to have $1 million in hard assets when you reach the point of insolvency. So we've got a system which is framed around a private profession, which quite rightly is there to make a profit, has to charge fees, are entitled to do so, but it's premised on the idea that there's money there to be used. Clearly, in a large proportion of cases, there isn't. Sorry, Blake, if you go to the next slide. So the next slide has some statistics put out by ASIC's report. Now, these are not the most up-to-date figures, and the reason for that is I'm basically treating last year as a write-off. So I'm going back to FY 18 to 19 rather than looking at the COVID year.
And we might assume there were a lot less last year.
Yeah. And if we look at that, the pre-pandemic period, that last line there in bold, 96% of reports, the estimated return to creditors was 11 cents or less. That's a number that gets trumpeted quite a lot, but it's really a misleading number, because if you look at the table in ASIC's report, it's actually 92% of those reports. The return is zero, there's nothing. So in 4% of all of those cases that had a report, bearing in mind the vast majority of those reports are by liquidators, not by administrators or receivers. But in only 4% of all those thousands of reports every year, is there any return to creditors. Sorry, Blake, if we go to the next slide. And I should just say that these slides will be available after the webinar, so I'm not going through all the different points. So
just adding a little bit of positivity there, there will be the cases, of course, which produce positive returns to creditors.
Sure.
And obviously that's the case. We're looking at averages here, aren't we?
Yes.
Percentages.
Yeah. So clearly there was some concern about the existing restructuring procedures, particularly voluntary administration. That's something that I'm quite interested in. I've been doing a PhD for some time on that and spoken to a lot of practitioners. And indeed, one of the criticisms that came out of that research is that VA is a one-size-fits-all procedure. Now it's very flexible. There's a lot you can do with it. But talking to a lot of practitioners, both legal and accounting, who work in the small business space would say that a VA is just, in most cases, too expensive. Unless there's some really pressing need that there's only something you can do using a docker, why would you use a VA for a small business? You're better off using a CVL. So here we see a statement from the explanatory memorandum saying, okay, there's a problem. One size fits all is a problem. We need a separate procedure for small businesses. And this is supposedly going to encourage small business owners to seek debt restructuring earlier and increase their chances of recovering viability. It is very interesting, sorry, next slide, Blake. It is very interesting that the stated purpose of the new Part 5.3b is not in fact to save the business, is not in fact to save the company, unlike that for voluntary administration. The stated purpose is purely and simply to put a restructuring plan to creditors for them to vote on. Whether the company survives after that is another matter. So it's interesting that the government has created this new regime, which when you add up all the sections and you include the regulations, is actually longer than Part 5.3a. Indeed, if you look at the regulations for Part 5.3a, I think there's about 11 regulations over a couple of pages. There's 40 plus pages of regulations for this new procedure. And one way that we might summarise this new procedure, if it's supposed to be streamlined and more cost effective than the more complex VA, is that this is seriously overcooked. That they're putting a whole lot of law into this new procedure, adding a whole lot of complexity, and in doing so, also adding an awful lot of ambiguity, which is going to need to be litigated at some point. But this is just going to be too complicated and too expensive to actually achieve its goals. Now, on this slide, I've just got a quick summary of roughly how it works. I need not trouble you with all of those points. The third dot point, I think, is worth pointing out. This has been sold by the government as debtor in possession, as so-called taking the best features of Chapter 11 in the US. Chapter 11 in the US, which is known as the lawyer's picnic in terms of the fees that get charged and the expenses involved, where studies have shown that you've got to have basically at least 5 million in assets in order for it to work. But I think it's actually disingenuous to call it debtor in possession. It's not really debtor in possession. I've referred to it facetiously as the ATO in possession. And the reason I say that is because even though the debtor maintains management power, so they're not automatically excluded because there's no external administrator, at least for the purposes of the Act, the restructuring practitioner stays on the side. But the power of management is limited to the ordinary course of business. Now you might think, well, that gives quite a lot of flexibility. Chapter 11 has that limitation. CCAA procedures in Canada have that limitation. The new moratorium provision in the UK has that limitation. Only the regulations then tell you what is not in the ordinary course of business, and it's not in the ordinary course of business to pay admissible claims, okay, fair enough, they should be covered by the plan, or to sell the whole or any part of the business. Well, what does that mean? And it was very interesting in the explanatory statement, Treasury said, if you had a business, for example, that was running a cafe and you had 2 fridges, and you realise you're in financial trouble, and so you decided you want to sell one of the fridges, well, that clearly would not be in the ordinary course of business, so said Treasury. You'd need to go off and get the permission of the restructuring practitioner, which I've called the small business restructuring practitioner. That's ludicrous. So really, the restructuring practitioner is not just sitting on the side, monitoring, checking to make sure nothing dodgy is going on. They're basically going to have a hotline with the director because every other decision is going to need approval. Well, all of that is going to factor into the risk for the practitioner. And yet we've got a regime here that says you've got to charge a fixed fee up front that can only be varied if you get involved in litigation. And then in terms of now that's just for the period of restructuring. In terms of the plan itself, you can only charge a percentage of recoveries for creditors, of distributions to creditors. So this is a procedure that I just struggle to see how it's all that attractive for the profession because there's an awful lot of risk involved not a lot of fees that can necessarily be drawn from it, and also not a lot of flexibility. The things that you can put in a plan, for example, you can pretty much only pay cash. You can't have the plan go for more than 3 years. So there's not a lot of flexibility there. And every creditor in the plan has to basically be treated equally, including the related parties. So we exclude the related parties from voting, and yet we say related parties who are also creditors have to be treated exactly the same as all the other creditors. Well, the trade creditors are going to love that, which is why there was a LinkedIn post today from a Victorian barrister called Brendan Devaney, who I don't know if is participating in this, but I thought this was interesting. Generally, this legislation is the worst nightmare for trade creditors, an economic disaster for restructuring practitioners who are paid pretty much nothing for their work, and an absolute gift from above for directors. So query how
Apart from that, though,
it's not too bad.
Yeah.
And the fact that, it's 100 pages of new law, a lot of which isn't very clearly expressed.
and you'll write the new chapter of key for
Yes,
on this.
I'm already onto it, Michael, halfway there.
Can I just interpose a question? I'm not going to bother
Sure.
flicking between the screens so you can see me, but involvement in the recent reforms by practitioners, external parties, and I would suggest the two of you, did you have any involvement? Do you understand what the involvement or the limit for the involvement was?
So I did in 2 capacities. So the Law Council of Australia was involved in consultations, and I was on their subcommittee that was involved with that. And they had multiple meetings with treasurers, with the Treasury Department. I was also involved as just an individual, providing comments. And it seemed to me that there was such a constrained time frame, even though there was quite a lot of submissions put through. And as part of my PhD research, I've actually read every single submission. So there's something like 80 odd submissions over the multiple rounds, some of which are 20, 30 pages in length.
I think you had a week to put them in, is that right? Or
Yes.
something like that?
Yeah. And the second round was even shorter, it was only 5 days. And almost every one of those recommendations in the submission was ignored. There are a few that were picked up, and that's good. But it just seems to me objectively that clearly the minister's office or the minister had, this is what it needs to look like, and that's basically what we got. Even though, for example, going back to that comment from the barrister, this is a disaster for trade creditors, because unlike in an administration where the administrator can say, look, don't worry, all the new invoices, I'm personally liable, so it's business as usual, we're going to trade out of this problem and come up with a plan. We don't have that here. They're just further debts being incurred. And if the director's got one eye to the exit, they can incur all the debts that they like, having the benefit, now it has to be within the ordinary course of business, having the benefit of this new safe harbour for the restructuring, put whatever garbage plan they like to the creditors, and then, oh, it got voted down. Oh, well, I'll walk away. Oh, and by the way, there's no liquidation at the end of that. The keys just get returned to the directors and they go along their merry way. Treasury's response is, oh, well, of course they'll be mindful of insolvent trading. I don't think they will. I think they're worried about losing their house because they've guaranteed the company's debt. And I think that's a far more powerful motivator than the possibility that someone's going to sue them in 5 years' time if they end up in liquidation. They probably will never end up in liquidation because they're just going to abandon it. Just leave the keys, leave the shop, abandon the assets and walk away. So that's a concern that I've got. On this slide, I've just got the basic eligibility criteria. I think most people are probably familiar with that, so I won't dwell on that too much. So next slide. On this one, I've got the effect of the restructuring. So this has got some of the time frames. It's supposed to be a relatively quick process. So all up's supposed to be about 35 days. If you go into a plan, the plan can last for a maximum of 3 years. The problem that I've got with this procedure is the government has said, well, we wanted to not concern people too much. So we wanted to copy as many features of VA as we could so that people basically understood what their rights would be. So they've essentially just dumped in Division 6 and 7 from Part 5.3a. And if you've got a procedure that's only supposed to go for a couple of weeks, I just think it's complete overkill. Why couldn't we say, guess what? Everyone's interest is stayed for the 3 weeks. And if you've got some extraordinary situation, then you can go off to the court and seek an exemption for the stay. But no, we've got, if you've got perishable goods, if you've commenced before, if you've got a major security, we've got 101 exemptions like there is in administration. But the thing with administration is, as we know, some large administrations go for years. So of course there should be exemptions there. And yet all of that has been dumped in. All of the the nonsense of the ipso facto, 68 different exemptions has all been put into this new procedure. And you haven't got an external administrator who's explaining it all. Supposedly the director's supposed to wade through all of this. Well, I mean, that's just ludicrous.
We're in mid-March. What are the latest figures on use of this provision?
So I did a search of insolvency notices this morning, and there were notices of 3 appointments of the small business restructuring, and there were 19 notices posted for the declaration. So this is the idea that you have passed a resolution that the company's insolvent or likely to become insolvent. You want to appoint a restructuring practitioner, but you haven't in fact secured an appointment yet. And so you file the notice with ASIC, you publish it on the Insolvency Notices website, and then you get the benefit of 3 months temporary safe harbour for that period once you publish the notice. So there were 19 of those. So that doesn't mean that we're going to have 19 new appointments coming up. Some of them might not proceed to an appointment.
Well, just maybe touching the question we've just received, I won't name the people who send the questions through who don't have their consent, but what I'll do is, if they're relevant, jump in. Do you think that current regime, or this regime you're talking about now, is in line with a government policy to not protect but look after directors in some format? Is it director focused?
No, and actually, if we skip forward 2 slides, I've got a slide on directors and restructuring. Yep. So I actually don't think there's that much in this for directors. So what are they getting from this? They're getting a very short protection from guarantees, but only for the duration of the restructuring, which is basically 3 weeks, might be extended another 10 days. They're getting no protection once you go into the restructuring plan itself. So that's pretty cold comfort. They do get protection from if the ATO serves a DPN. So that might be a benefit to some people. If you've got a business which is basically viable, but you've just got a few debt problems that you need to deal with, you've got a largely supportive creditor base, you're not in too much trouble with the ATO, then maybe that will be helpful. But for a lot of those, you might be able to do a deal anyway, even without the added complexity of this procedure. The related party debts are excluded. On the stats on the earlier slide, which you don't need to go back to, huge proportion of the debts in small business insolvencies are related party debts. Well, they're excluded from voting on this. Now, they're still creditors, so they still have admissible claims. They're still entitled to be paid out of any plan, but they have no control over it. So if I was advising a director, you say, well, hang on, notionally you're going to have control of your business, but not really because of all the exceptions to ordinary course of business. The ATO essentially is going to determine the outcome because they're probably the largest unsecured creditor who will be able to vote. All of those loans that you've been extending to the company to prop it up over the years, well, basically, we're just going to ignore those for the purposes of voting. What's in this for the directors? Now, there's some stuff in this for directors if they've got perhaps some, different sort of purposes. One of the things that we need to look out for here is if directors have taken security over say an ORPAP over the company's assets, and the directors suspect that suppliers have mucked up their PPSR registrations, there's a provision in this procedure that says directors can cancel it at any time by serving notice on the practitioner. They don't even have to give a reason. So directors could appoint a practitioner, cancel it the very same day. Any PPSR registrations that are problematic automatically vest in the company. Why they put the vesting rule into this, I don't know. I suspect because they think it's just like administration, except it isn't just like administration because you don't end up in a liquidation necessarily. So a director could terminate the process, cancel the PPSR registrations, and then it just goes back to their control. So it doesn't go into winding up like it does in a VA when it's cancelled. So it's just very curious. I'm not sure what the incentive for directors here are, Michael.
Could I just say something about that particular topic, but harking back to some of those figures earlier, it's something I might have said then. When we talk about small business, and you referred to statistics from ABS, but also Small Business Ombudsman has put out some good reports called Small Business Counts. And I think this has always been the case, but it seems to be forgotten in this whole law reform process. The government's talked about SME reform. They're talking about SME corporate insolvency reform. Companies, in fact, comprise, in small business, comprise less than 40% of all small business. And over 60% are sole traders or partnerships, in other words, operate through individuals. And I can get onto that shortly in respect of the bankruptcy reforms, but even in the context of a director of a company, As you've got up there, Jason, there's going to be personal guarantees, so there's going to be personal liabilities there. And I don't know what your experience is, Blake or others, but I think in small businesses, directors assume a lot of personal liabilities on behalf of the company, and it's all intermingled in a very unsatisfactory way. And yet this is all about the company itself, but not so much the directors, but the directors as individuals and what will happen to them. And of course, if the directors go bankrupt, I'd be interested to know if one of these successfully went through, but the directors nevertheless went bankrupt. The whole company would vest in the trustee. I'm not sure what a trustee would do with that. But you said earlier also, Jason, there's no real incentive for someone to go into Part 5.3, but of course it would trigger personal guarantees. And you say, well, they might trade on and they might then ultimately just abandon the company and walk away. That's something else I'll get to a bit later, but abandoned companies. Last figures I saw were there were 5 times as many abandoned companies as there were companies that went through external administration. And this is one of the big picture issues that Jason and I are looking at in terms of government involvement. Is it satisfactory that all of those abandoned companies disappear off the register without being examined? There are suggestions that there's a lot of Phoenix companies in there, but also, as you say, Jason, ones that just drift off into the never, unable to access Part 5.3b, and is that satisfactory in terms of how the insolvency system operates?
So I mean, the last point on this slide, so if you're advising a director and they're saying, oh, well, you know, I want to try and do a deal with my creditors, and maybe I've got one or more creditors who might go off and try and get a winding up application. Of course, there's no automatic stay for winding up applications. You've still got to go off to the court and make that argument. But, you know, this procedure is not going to be free. If you've got a business that's really struggling, the idea that the business is going to have a spare 10,000 or 20,000 or whatever to pay up front for the insolvency practitioner, I'm just not sure that it's all that realistic. Some businesses will, sure. But if we go much beyond that, if practitioners start, you know, quoting, oh, well, it's minimum 50,000 to do one of these because there's an awful lot of personal liability risk, then you'd have to say, well, how is this any cheaper than a voluntary administration? And yet there's a far more flexibility in voluntary administration. So I think the result of this is going to be those hollowed out businesses from last year, they're just going to walk away, just hand the keys in, abandon the store. You know, just start up a new business. And of course, there's no restriction on doing that. Now we might move on to the other reforms. Blake?
Yeah.
So in terms of simple liquidation, I've just got one slide on this. I'm not going to take you through all the details. But again, the idea is, and if we go back to the Small Business Family Enterprise Ombudsman's report saying that, you know, liquidation is very expensive and often there's no returns to creditors, and, you know, lots of creditors are frustrated about this. So the government comes up with the idea that we should have a simplified liquidation process. And I'm all for that. We should absolutely have simplified systems. We should look to all of our insolvency procedures and see how we can cut costs and make it more straightforward and more streamlined. The problem is what we've ended up with. Now, part of this might just be a lack of sufficient consultation. So there's lots of submissions, but if you only give a week or two to process those and then largely ignore them anyway, that's not really helping the process. If we had a proper kind of law reform commission review of these sorts of issues, look at best systems in other jurisdictions and see what works and what doesn't work. And just, you know, this is something Michael and I have been talking about for a while, but the idea of maybe we should revisit the whole idea of external administration and how that works. Maybe there's a proportion of businesses and individuals that actually can't afford this system. You know, whatever it costs, they can't afford it because they have nothing. To a certain extent, we recognise that in personal bankruptcy through the official trustee, which handles over 80% of bankruptcies in Australia. But certainly we don't have that for companies. So the idea of a simplified liquidation, the problem that I've got with this simplified liquidation is I just don't see how much simpler it is. There's a few things that are simplified. So there's no formal proof of debt procedure. There's no provision for creditor meetings. You can't have creditor meetings. That's a little bit simplified. The creditors can't force you to have a creditor meeting. That's a bit simplified. But if we're comparing it to CVLs, which of course what this is, it's a new category of CVL. They largely got rid of creditor meetings in 2017 anyway. There's no 533 reports. However, there's still an obligation to report if you become aware of any offences and it's likely to be a serious offence. So there's still some reporting obligations, and you've still got those obligations to comply with creditor requests for information and creditor requests for reports. So there's nothing to stop Fed or a creditor coming in and saying, oh, by the way, why don't you just give us a report on all these different things that you've been doing, even though you're probably starting with little or no assets. So they're not, it's like Clayton's law reform. They're making things more complicated and more uncertain and saying somehow it's going to save money, like the ILRA supposedly was going to save $50 million a year. It's pretty laughable. If we just go on to the next slide.
Just on, it might be on this,
Sure.
just before we move on to safe harbour, just a question, Michael touched on this before, the reforms missed the mark in terms of the demographic of who they're seemingly aimed to attack. So I can't recall the date, I think it was October 2020 was the Joint Treasury publication which talked about the reforms, and it said in there that 73% I think of businesses this will assist, but I don't think that they had thought about in that notice that a large portion of the people falling in the $1 million or less liability category are in fact either sole traders or in some form of structure different to a company. So Michael, I need if you want to, that might be a good segue into that.
Yeah, don't get me too much started on that because I'll talk too long, but it's the way that insolvency is administered here. We've got Treasury looking after corporate insolvency and Attorney General's looking after personal bankruptcy. And even in the dramatic circumstances we've had of business collapses following or distress following COVID, we've still got these separate lines of law reform operating, and neither one much referring to the other. And that's a real bugbear of mine and something I've got views on. I might just mention one particular view, and it comes up, maybe I'm just jumping a little bit if I could, Jason, but there are personal insolvency reforms at the moment, and they're to do largely with 1 year bankruptcy. And I think we know what that means, reducing the term from 3 years to 1. I've been a bit radical out there, it seems, according to some of my colleagues. Some of them questioned I won't tell you what they've questioned, but anyway, in terms of how I've been thinking, there's a real disparity between a person who goes bankrupt, as I said, running a small business, and they've operated in their own name, or they might have given a personal guarantee, and they're out of contention, or they're restricted then for 3 years or even 1 year. Whereas a director that administers a company and goes into insolvency is pretty well has no automatic restriction on their further conduct of businesses. And I just think I would have thought when I said 2020 might have been a good year to sort of reset our thinking about insolvency. That's one that I suggest we have a bit of a think about, in terms of lining up the accountability obligations of those who are personally bankrupt and those who administer an insolvent company. In insolvency, corporate insolvency, academic like Jason will tell me properly about the separate legal entity principle, and it's not the director who's incurring the debt. I know that, but nevertheless, the law can cut through that, and it does in terms of the director's obligations to lodge reports as to affairs, etc. I think that's something that we should look at. So rather than talking about a 1 year bankruptcy, I'd rather see some focus on, what period of accountability should there be for both directors and bankruptcy in terms of what do we expect of someone who has been through an insolvency. And this also, the bigger picture there is, Australia's attitude to unpaid debt. And there is a lot of comment about Australia is rather severe on that. And you might see some of the reactions to even reducing the period of bankruptcy from 3 years to 1. That's a bigger picture issue that, in terms of when we're saying we should rethink some insolvency law, we'd have to confront.
Well, I mean, just on that point about, the overlap, particularly in the small end of the market between personal and corporate insolvency, and the idea that as a default, I know sometimes there's an exception to it, but as a default, we have separate insolvency practitioners, bankruptcy trustees and liquidators. Now, you can go off and get a joint appointment, but just the way that we're thinking about that, I mean, it's ignoring reality. The law says that a company is a separate legal entity, but the business person probably never treated it that way. And there's, as you say, there's a mixing of personal and business assets. We see it all the time. Even in some very large businesses, there's a lot of mixing. So just rethinking what it is that we're trying to achieve there. Because if we're thinking that we're achieving full transparency and accountability. I'm just not sure that we are. If you're starting with nothing, it's very hard to conduct a thorough investigation. So maybe we need to rethink how that operates, and that has to include how it's funded, and it should also include who's doing it. So I'm not saying, well, we must have a government liquidator who's going to take 80% of the corporate jobs. I'm not saying that. But I think we should be considering who should be performing what role, because at the moment it's focused solely on a private profession and there's not enough money to pay them. And that's just a reality. So either we're accepting suboptimal outcomes because there just isn't the money to do the work, so they do what they can, doing the best that they can, or in many cases, it's not happening because there's a lot of companies that are just bypassing the system. And some might say that shouldn't be a problem because it's ultimately for the benefit of creditors. And if the creditors don't want to take a winding up proceeding, that's on them. And we can just have this, the road filled with former companies that are just lying there dormant, rise of the zombies. But I think it is a problem because we are seeing a lot of stuff about Phoenix activity and so-called improper Phoenix activity. And there's a comment about the new anti-Phoenixing measures that I'll come to in a minute. So clearly some people are worried about this from a policy perspective. And yet, we seem to have our tunnel vision on, well, this is either a corporate problem or it's an individual problem. Well, it isn't. It's an economic problem. And we need to deal with it as such.
I knew this would happen in a nice way. I thought we might come to a shortened time frame. So we'll just move on to the next topic, which we were talking about before, which is that there are 4, in fact, safe harbour provisions that I have been educated on. So this morning, so I'll pass you on to that next topic.
Yeah, sure. So if you look in the Corporations Act, which has recently been consolidated for the new reforms, if you look on OSLI or the Federal Register's website, you'll find that there are 4 safe harbours. So we've got the original safe harbour, 588GA, and now we've got a new safe harbour, which is the COVID safe harbour, 588G AAA. We've got the extension of the safe harbour, that is the original safe harbour, specifically to restructuring, a period of restructuring, which is 588G AAB. And then we've got a further extension of the safe harbour under the temporary restructuring relief provisions, which is this, if you filed a declaration between 1 January this year and the end of March, which is 588G AAC. Now, for those who've studied any taxation law, you might see a familiar thing here. The people who write the corporations legislation, what else do? They also write tax law. So this is what we're seeing here, proliferation of legislation. And one of the pictures that I've got on I think it's the third last slide shows, at least in my view, we can't fix these problems with more law. The problem is not that the Corporations Act isn't long enough. That's not the problem. The problem is that we continually refuse to look at the bigger picture and we keep greasing the squeaky wheel. We think, oh, there's a problem here, so we'll introduce some new law on that. And then someone else complains, there's a problem over here, so we'll introduce new law on that. And we're not standing back and thinking, how does this actually relate to what's already there? The problem of Phoenix activity, at least in my view, is not that there's a gap in the law. It's not that there's no provisions that ASIC or liquidators can use to tackle improper Phoenix activity. It's that there's no money to do so. And there's no legislative will or regulatory will through ASIC to do so, or at least to do so comprehensively. The odd show trial and the showcase to one side. So we see this proliferation of safe harbour reforms. Now, I won't take you through each of these. The middle one I think is kind of interesting. This is the one that if you incurred debts between the end of March last year and the end of December last year in the ordinary course of business, then you're automatically covered by a safe harbour. Of course, some jurisdictions simply said their insolvent trading laws did not apply. We're doing that by way of a safe harbour. But it's the clumsy drafting. This debate that's been had over LinkedIn over the last few months, did you have to make an appointment before the end of December in order for it to be exercised? Treasury was well aware of that and they chose not to fix it, not to clarify it. And it's just emblematic of, the state of our insolvency reform is that we're constantly reacting to things when many other jurisdictions, look north to Singapore, are saying, what can we do to make our insolvency laws better? Not just deal with what people are complaining about. Sorry, next slide, Blake.
So proactive rather than reactionary.
That's right. So you get a safe harbour, you get a safe harbour, everybody gets a safe harbour. Next slide, please. Okay, so then the so-called anti-phoenixing measures, these were brought in last year, creditor defeating dispositions. So what are they doing? They're saying a creditor defeating disposition is a disposition of the company's assets which prevents the property becoming available or hinders the property becoming available for the benefit of creditors if you're going to a winding up. It's an effects-based test. It doesn't depend on insolvency, although if it's going to be voidable, it does depend on insolvency. There's also provisions, next slide, please.
Just a quick question. I might just ask it before we move on.
Yeah, sure.
For context, the question is the date supposed to be 24th of March? 30?
2020.
Or 31?
Oh yes, sorry, that's well spotted. On 2 slides ago, I had 2021 when it should be 2020. Thank you.
I'll move forward.
Yep. Sorry, back 1 slide, thanks. So we've got the new concept of a creditor defeating disposition, which is also a voidable transaction in certain cases. But then we've got these new offences. So it's one thing to say, well, if you're engaging in a transaction which is at less than market value, which is going to hinder the recovery for creditors, we're going to make that voidable. One point there is to say, but hang on, what about 588FB? We've had uncommercial transactions and unreasonable director-related transactions in the law for many, many years. Why do we need a new procedure? Is that why all of these undervalued transactions weren't being enforced? No, it's because there's no money to start with. Because the people who do this are reasonably adept at it and ensuring that there's not enough money at the end of the process so the liquidator can't chase them. The problem isn't a lack of law, it's a lack of money to fund enforcement action. And then we've got these new civil penalty procedures and criminal procedures where if you're participating in one of these undervalued dispositions, then you're potentially liable to a civil penalty, you're liable for strict liability and potential criminal liability. And if you're advising on it, you might be said to be procuring a creditor defeating disposition. Next slide, please. So that may well have a chilling effect or certainly slow down commercial deal making because you've got to ensure that at least you're getting market value, which is some benefit, or that you get the benefit of the safe harbour. And then we've got this new power that ASIC has, which is effectively 139ZQ from the Bankruptcy Act with the official receiver. But it's more than that. You know, we had a constitutional challenge to 139ZQ many years ago, but this procedure goes further. So it's not merely ASIC saying, either on an application by the liquidator or on ASIC's own initiative. So ASIC can believe that a disposition of the company's assets is a creditor defeating disposition and can serve a notice on the person who received the asset saying, we think this is a creditor defeating disposition, you've got to transfer it back. That's what the OR can do with 139ZQ, but this one goes further. ASIC can require payment of the value of benefits received by the transferee. There's no court application here. This is ASIC saying, you took a disposition of the company's assets, which we think was at an undervalue, and we believe that you've received this financial benefit. So you've got to pay that whole amount to the liquidator, otherwise it's a criminal offence. And the only way to get out of it is to challenge it in court, which of course you have to do. I think that's constitutionally invalid.
Harking back to something we were saying earlier, you know, there's Treasury looks after corporate, Attorney General looks after bankruptcy. There was a good precedent. As you said, it survived a challenge under 139ZQ of the Bankruptcy Act, which could have been adapted for corporate, but instead they've started afresh. And as Jason said, he feels there's concerns about the breadth of this provision here.
I don't have confidence that ASIC is an appropriate party to be valuing commercial transactions.
How often do you think they're going to use it though? Have they used it yet? Is anyone?
Not that I'm aware.
I do have an application at the moment. We're looking to use it, but I've not heard of anyone who has actually used it yet. So if there's anyone listening, if you have used it or you've sought to apply to ASIC, let us know. But
you might end up in the High Court.
Yeah. So I've got some concerns about that. And then on to the next slide, please. So this brings us towards the end of the discussion about recent insolvency reforms. My main point here is, what's the answer to these perceived problems? That the system isn't working well, that it's not generating a lot of returns to creditors. The answer that we've been given time and again over the last 5 years is more law. That's not the answer.
Okay, can I just say something on that? And just going back to the Phoenix laws, I mentioned earlier about abandoned companies. Now, One very useful reform that I think is coming in and was initiated, I'd like to acknowledge, by one of our academic colleagues, Helen Anderson from Melbourne, is the director identity number. Now, whatever directors or others think about that, I think that will be a very useful addition to what I think is the need for transparency in this area. Because one of the submissions that went into government in support of the director identity number, and it's going back to that issue I said about abandoned companies, there was some figure in one of the submissions, it might have been an old figure, but it was talking about something in the order of 70% of abandoned companies were involved in phoenixing. Now, whatever study was done to substantiate that was explained in the submission. And so, but the government, allows companies to drift off the register, as I said, because it's a convenient, you can't afford to go into Part 5.3B or 3A, and you haven't got enough money for a liquidator to go through liquidation, so drift off. But that in itself is a very opaque process that I think can hide a lot of misconduct. And yet, at the same time, not being so much worried about that, the government passes this great raft of legislation in effect to counter Phoenix activity. I mean, on the one hand, and this, you see this a lot in criminal law, you see, rather than fixing the causes of crime, they just create a new crime and put more resources into police and regulation, etc. And that's what.
But that's what we're missing. The second bit is what we're missing. They're creating new provisions and new offences, trying to threaten people, but there's not the follow through with the extra resources.
Well, but the regulation, I don't know if we differ on this or not, but certainly prevention is better than cure. And one way of prevention is transparency. And that's where I think the director identity number is something. And there's also going to be, I think these are on hold, these reforms, pending the outcome of, the dramatic consequences of last year. But there was also to be a disclosure of tax debts, to credit reference agencies. Now that's a pretty, out there sort of measure, and I can see why it might have been put on hold last year. But you want to know who you're dealing with, and at the moment it's a very dark, environment out there in terms of knowing, what name is, even the name of the director you're dealing with, or who's behind the company, who the shareholders are, who the beneficial owners are, all that sort of thing.
I think COVID might bring to light, particularly in the construction sphere, these straw directors and how many there potentially are out there. Just on that comment, Jason, do you know of any reason why they haven't adopted? Is it simply resource based? The reason they haven't accepted the DIN as a good concept? Is there a reason that it's...
Oh no, I think it has been accepted by government as a good concept.
Oh, the legislation has been passed through Parliament, but it's yet to be implemented.
And the implementation date's quite, that it seems to be something that should have happened quite some time ago, in my view.
Well, what I'm saying is they may have put it off because of last year. I don't know. I mean, I did try to find out, but I guess
that just seems like a reason to bring it forward, in my view. But
well, indeed, yeah.
I think it got delayed in part because initially it was held up with the Modernising Business Registers project. So you've got this huge project to consolidate Commonwealth registers, which is really complicated. Lots of different systems and moving them new to a new body that's going to oversee them. So I think it got delayed with that. Now that it's been excluded specifically from that, it is moving forward. But there's also some complications in terms of how do we ensure that we get all the existing directors on the register, not just the new directors. Could you go to the next slide, please? So I guess what's our answer to this? It's not a very satisfactory answer, but our answer to these concerns is that we need to stop doing what we've always done, which is greasing the squeaky wheel, and we need to really rethink. We need a blank sheet of paper and say, if we were going to start again, would we end up with the system that we have now? Be clear about what it is we're trying to achieve. Be realistic about how we might actually achieve those things, rather than, it seems, at least from my perspective, ASIC's approach of basically flicking off the responsibility to insolvency practitioners by calling them gatekeepers. Oh, well, if there's not more enforcement action, that's because the insolvency practitioners don't give us all the information. Well, they don't give you the information because it's not there, because the company's been stripped bare and there's no money to do so. So until we address that problem, we just keep going around in circles. And it seems to me almost everyone is dissatisfied with the system. No one's completely happy. And then on the last slide, please.
And I wonder what the reduction, I'm not trying to do myself out of work, but reduction in legal costs and other costs along the way would effect would be.
Well, that's one thing that would have to be on the table is when do we go off and seek court approvals for things, as an example. So something I've been looking at in my research on voluntary administration is the fact that to go off and get an extension of the convening period, you've got to go off to the court. Why? It's almost a pro forma now. How many cases have been knocked back? I can only think of one in the last 25 years. So why don't we simply allow creditors to approve that, for example? So yeah, I think there's lots of, processes that at the moment we say, oh yes, you've got to do this and go off and file here and get this permission and whatever. All of that needs to be rethought about what we can realistically achieve. But until we come up with what we want to achieve out of this system, we're going to keep being disappointed.
And can I just mention there too, bankruptcy was my original discipline, then corporate came later. Corporate insolvency there's a great disconnect, certainly in terms of getting court approval for various things. And I've queried why you have to go to court as a liquidator to get approval to enter into a funding agreement. There might be, levels of amount that you might set as the criteria, but certainly a trustee in bankruptcy doesn't have to do that.
So I'd be happy to take questions or comments.
Yeah, I think what we'll do is I don't know, we'll get through. I've got a number sitting there.
Great.
What I'll do is I've just got I've got to flip between my phone and what's on the Q&A because they're coming from all directions. But what I might do is just work on some of the text message I've got so far. Firstly, why would suppliers extend credit? And some of these, there might not be an easy answer. Why would suppliers extend credit to a business in SBR when they've already admitted they're insolvent?
100% agree. Yeah, it'll switch to cash on delivery.
What obligations exist on directors to disclose to suppliers the SBR when obtaining credit on the supplier?
So just as we have with external administration, on your public documents, you need to put notification there. And it'll also, of course, be on, ASIC's register if you do a search of the company. Yeah. And one of the things that's odd is the way that they framed it, that, in business restructure, it's got this incredibly long name, which I wonder if that'll spook some creditors.
Yeah. And if there isn't an obligation, how are creditors protected from rogue directors preferring self-interest? But
They're not.
Yeah. I've got loving your insights, Jason and Michael, as we all are. Don't quibble with any of it. Singapore took a clean sheet view and approached the build out of its new insolvency and restructuring law based on a global best practice criteria. Why can't we do that here?
Yeah, totally agree, Mark. And Singapore did it over several years. So they had their Law Reform Commission report, which took several years and was reported in 2013. And then there was a lot of soft consultation with industry players over the next several years. And then they came out with the big reforms, whereas we tend to do things very quickly, not allow a lot of time for consultation, and have quite narrow terms of reference. So it's just, if we do this, we're not challenging whether we do this, it's how can we make this specific rule better? And we miss a lot of stuff. We miss the connections with the existing law. So that's why we've argued for several years now that we need another Law Reform Commission report.
Could I just say something on that, maybe a little bit to contradict it? And I'm speaking against myself as a lawyer and anyone else out there as an insolvency practitioners. I think we need other disciplines to come in and look at the regime, because what we tend to look at is the detailed avoidable transactions and recoveries and conduct issues. But what I've been looking at, and with Jason, is the structure of the regime itself. And it's some of the things I was mentioning at the beginning. The system can't, I think the whole system needs to go through voluntary administration itself and come through a deed of company arrangement. Get rid of some of the tasks that are loaded onto the regime, and even under Part 5.3b, where all these, what I call public interest tasks, are put onto practitioners. And then they're blamed because, that they don't report properly or things don't go well, or creditors don't get enough money. I just think you need a bigger picture, and I don't know what sort of discipline that is. I suppose it's from economics and it's from a management perspective. And I also, if I could just throw in there, artificial intelligence, I think, is the way of the future in this area. I gave a talk on that recently, not that it's my area at all, but I don't think we can do the things in the same way of lodgements and documents and reports that we have been doing for the last, let's say, 100 years, even if they are sent by email or whatever. I think we've got to start looking at new mechanisms.
And we've got one here. Is there safe harbour for COVID for the COVID period, March to December 2020, if the company took no action at all. Also, it's a second question, but also can an unfair preference be pursued for the COVID period if the company did enter into an insolvency process during the COVID period?
So the short answer is yes. So it's 588G AAA. This is the so-called COVID safe harbour. And all it's saying is that a debt incurred during that relevant period that they've got in the question, as long as it's incurred in the ordinary course of business, then you're protected by the safe harbour if you then appoint an insolvency practitioner. Now, we could get into a technical, interpretive, legal argument about whether you had to appoint the practitioner by the end of the year, or whether if you appoint the practitioner now, you'll be covered for what happened last year. But, you know, I'm sure they could come to you for advice on that, Blake.
I think they probably can.
And with respect to the second question, I actually don't know off the top of my head. I suspect that yes, you would still be subject to unfair preference laws. But of course, if you then went into a simple liquidation, you've got that new restriction on no more than 3 months if it's not a related party, and only those over 30,000. So that might come into play if we've had a company go into a simple liquidation nowish.
We're sort of getting towards the end, but we've got one more here. The major problem for court liquidations is that should the director not comply with the liquidator regarding a ROCAP, etc., the recourse by ASIC is to fine that director a nominal amount of $3,000 and usually then take no further action. If ASIC took firmer action against the non-compliant director, the liquidator may be more successful. Your thoughts?
I'd like to answer that one. And could I answer it this way? Back in 2015, there was a proposal that there be an automatic restriction on a director of an insolvent company where the director has not filed a ROCAP. Just as in bankruptcy, if you don't file your statement of affairs, it's an automatic process. It's not a matter for the official receiver or anyone to do anything. Your bankruptcy is extended. Likewise, the idea was in corporate, if the director hadn't filed a ROCAP, they would, and it's a matter of degree as to how much you would apply this, but whether they couldn't take new directorships or their other directorships were on hold or something like that. And that's a far better process than saying, oh, ASIC should do something. And I'm not criticising ASIC here at all, but it's better to have a default provision and put the onus back on the director. You know, why should we be running around chasing up director defaults when the law can do it for us by way of, a default provision? But that was rejected at the time, and this is where there's a great disparity between personal and corporate insolvency. That was rejected at the time as being too unfair on directors, that they haven't complied with their obligation to the liquidator in this matter, but that shouldn't, impede their entrepreneurial directorships in other matters. I think that's too far in their favour. Certainly when you compare it with an individual in bankruptcy who, the bankruptcy is extended interminably if they don't file their statement of affairs. Good question, thank you.
And I think before I said we went up the names of those asking questions, but inadvertently they've come up on the screen anyway. So the last one is from one of our own colleagues, and that's Simon Gallant. Sorry, there's one more to come through. I think we'll have time to answer that too from Mr. Hosking. But on the creditor fitting disposition issue, it would, on its face, capture a bona fide sale to a third party who, in the process of DD, ascertains the company is in trouble and so is able to negotiate a reduction in price. How on earth is one supposed to determine market value in that matrix?
Yeah, it's tricky. Yeah, I don't have an answer.
Should we take that as a comment?
Yeah, it's tricky.
It's tricky.
Yeah.
You'll be giving a lecture on that.
Well, thank you, Simon. Yeah. We'll take that as a comment. The next one is from Mr. Hosking. It is, is the fall in insolvency a function of ATO collection policy and pressure on banks with respect to their collection methods?
Well, that's a good question. And I think, as I said earlier, I'm no economist and probably you need economics to come in there and other disciplines. But as I said, we're in a lull at the moment. You might have expected insolvencies to increase this year. A lot of people are saying that a lot of that lies in the hands of the ATO. Jason earlier referred to the ATO in possession, but as far as I know, I haven't heard much from the ATO as to what they're doing, and I think a lot of people are speculating about that. Do you have any comment, Jason?
Oh, well, I mean, my comment in answer to that specific question is I think, yes, both of those, but also the changes to statutory demands. So, why would you issue a statutory demand if they've got 6 months to comply? So I think that just put certainly the ATO not being very active, the banks basically holding off, that's a big chunk of, particularly ATO, those who would put under small businesses, but then also just the standard enforcement processes.
And now, just as a quick comment, the need to check to see if a company's in a small business restructure before they're issuing demands, SAP demands too, the period will extend. So just being cautious for those out there who are, as of 1 Jan, willy-nilly issuing them, just to double check that as well, because I've seen it be missed already. Yeah, so I just raise as a comment. Before I say thank you, anything else you would like to add on a broader level? Any other comments you'd like to? You don't have to by any means. It could be just a general gripe with our laws, but
I feel like I've made that fairly clear. As a general comment, I guess I would say I think these are not problems that are unique to Australia. The issues that we're dealing with. There's a lot of jurisdictions around the world that have similar issues, that have similar systems, that are coming up with a variety of different ideas. And I think we're too inward focused here because we're very reactive. So if we took a broader approach and said, well, how should we deal with these types of processes, and actually looked at what other countries are doing, including, as you've said to me previously, Michael, countries like Norway that have a lot of electronic processes, and certainly some of the stuff that Singapore's doing. I'm seeing that more in practitioner conferences. What's India doing? What's Singapore doing? What's Japan doing, etc. I think we could learn a lot from what overseas jurisdictions are doing.
Well, one thing, can I just add one thing on that? And it might have been in your slides somewhere, but the safe harbour provisions, the original ones, were supposed to be reviewed after 2 years at the end of 2019. That hasn't happened. And then, as you said, we've got 3 more followed up from that without knowing how the first lot have been operating. I've got a big gripe, and I'm not saying how you resolve it, but we operate so much in the dark in this area. Our statistics are pretty woeful. Bankruptcy is a lot better. But I suppose, for example, I would like to think in respect of Part 5.3b, there would have been some process of review as to how that's operating.
Well, the Labor Party proposed that in Parliament.
And it was knocked back, I'm not getting politics into it, but it wasn't accepted by the government. So, we're sort of compounding our ignorance by just continuing on with further ignorance about how it operates, except in occasions like this when we all get together and we exchange anecdotes and issues. That's useful, but we need some more hard data. And I said earlier, the future is in artificial intelligence and computer-based applications, and I'll leave it at that without going on to explain it more.
Well, I think the comment on politics is an important one. We don't need to go into it now, but I think particularly in the ATO collection, whilst economics might come in, I think politics will be coming in the next 6 months too, but I'll leave that as a comment. Well, I'd just like to say, again, thank you very much for today. It's been fantastic having you both. For everyone who is on the stream, what we will do is provide an email with a link, the slides, as well as your CPD certificate. Next month, we've got another seminar with Omni Bridgeway and the Department of Jobs through Mr. Humphreys, talking about litigation funding alternatives. So the 2 of you might be on there sharing some comments. But otherwise, again, thank you very much to our 2 panelists today, and looking forward to next month. Thank you very much.
Thank you.